Sometimes you simply can't write the script. We're going through family court. Seems like reading a chapter of Alice in Wonderland and ending up at the Mad Hatter's Tea Party. The cartoon represents my sense of humour, but it's time to remove it because this is perhaps the most serious blog I have ever published. If you are the non-resident parent, particularly a father going through child arrangements, you really need to watch this. Miss it at your peril. What I am going to explain has potentially wide-ranging and serious ramifications for anyone going through the family court with a child arrangements application. The context of this blog is a Court of Appeal judgment recently published in the case of A and the coming into force of the Domestic Abuse Act 2021, which received royal assent in April. I am very familiar with this case because if you take a look at the judgment, which the judge has allowed to be published, I am named as the Mckenzie friend supporting the father. If you want to download the judgment, you can do so by clicking the link if you are watching this on my website or on YouTube. I can't wait to get into this, and you may find what I am commenting on very hard to believe, because it seems that common sense has now left the family courts forever. But just before I do, let's run my excellent introduction. I am Philip Kedge, a retired police chief inspector and director of the Mckenzie Friend UK network. I am the founder of the national campaign of #LikeNotHate that promotes a solutions-based approach through family court to prevent harm to children. The focus is to remove lawyers from the family court who all too often stir the pot of conflict and acrimony for financial gain, engage in thousands of pounds of totally unnecessary work, and have absolutely no professional duty of care to any child. How disgraceful. In my blogs, my views and opinions are entirely my own. Let's return to the blog. Now, the judgment has been published, so I am free to comment on it. However, having supported the father, I do have wider information. But this blog will be kept solely around my views on the judgment, which is the information in the public domain. I really don't want to end up spending the summer locked up at Her Majesty's pleasure on contempt of court charges. This Court of Appeal judgment is based on the appeal by the mother in relation to a fact-finding hearing. The appeal in part found that the judge minimised domestic abuse and did not apply the definition of domestic abuse. I am going to concentrate on two examples from this appeals hearing, which is in relation to paragraph 22. I would like to invite you to read this with me on your screens. It was alleged by the mother that the father shouted at C, the 15-year-old son of the father, from another relationship. So in the first instance, this incident isn't between the father and the mother's own child. This is the son of the father from another relationship. However, the child named as A from the relationship with the mother was also allegedly present. Now, the judgment doesn't give the age of A at the time of the incident. It was alleged that he, the father, called him, the 15-year-old son, a little shit. The judge found that the father shouted at and berated C, and that he did call him what was alleged. So at the fact finding, the trial judge, who is named as Deputy District Judge Watson, found that the father called his 15-year-old son of another relationship a little shit. Judge Watson then made a finding that it was appropriate to reprimand the teenager in that way, describing it, however, as inappropriate parenting rather than abuse. He found that A was present and exposed to the father's anger and temper, even if the cause of that anger and temper may have been reasonable. He said that the court was not looking for perfect parenting standards. So let's stop and pause there. How many of us can relate to that as parents? Bringing up our sons and daughters from birth through teenage years and into adulthood. It's not easy, is it? I had the t-shirt twice and it wasn't always easy. As parents, do things go wrong? Yes. Are there arguments and bust-ups? Yes. Do things get said in anger and temper? Of course. Do we at times swear and say things in frustration? Yes. Do teenagers sometimes actually act in ways that may be described as highly challenging and uncontrollable, that drives you to distraction? Yes. Is calling your son a little shit when they may be acting in a manner that has pushed all your buttons to the limit inappropriate parenting? Yes, of course it's inappropriate parenting. But it is understandable, and we all get it. Well, I guess the vast majority of parents do, unless of course we are such perfect parents from the planet woke that we are in total denial of our own imperfections and flaws. Is it child abuse? Of course not. That's ridiculous to any rational-minded parent. It's a parenting family incident and matter. Unfortunate things happen, and as families we kiss, cuddle and make up, and family bonds are grown even stronger. That's called love and nurturing. It's normal, it's natural, it's healthy. Oh, but not according to the Domestic Abuse Act of 2021 and the Court of Appeal, which I will come to in a minute. Let me go on to describe what appears to be a second incident before I explain the insanity. Judge Watson, the initial trial judge, referred to an incident where apparently C had broken wind on the father. Judge Watson said, "One might imagine a few expletives would be fairly reasonable in such circumstances. Believe me, if my son, when he was a teenager, farted on me, he may have had more than a few expletives to contend with." Again, as parents, we discipline, we guide, we support, we transform our children, and we make mistakes. We shout and express emotions, and at times that may not always be appropriate. That happens because we are human beings. We live in the real world. And with all the stresses, challenges, and imperfections of the real world, not on some ideological, non-existent planet of perfect parenting. So here we have Judge Watson, who seems to have his feet planted firmly on planet Earth. A judge who understands the rigours of parenting, the ups and downs, the roller coaster ride of emotions, the challenges and rewards. A judge who was able to apply common sense, sound reasoning, a level of humanity and understanding. A judge that you would turn to as a wise family member to help resolve disputes. A bit like a village elder. Exactly the kind of judge the family court so desperately needs. So what did the Court of Appeal say about these family parenting incidents with His Honour Judge Ahmed? Judge Ahmed starts off by stating that the new Domestic Abuse Act of 2021 came into force as recently as April, and that it makes far-reaching changes to the way in which domestic abuse is addressed by the family court. He's not kidding. What's interesting about that statement is that we of course don't know what Judge Ahmed himself is actually thinking about these changes. It could be that judges up and down the country are viewing it as some kind of slow motion car crash that is about to hit the family courts with multiple serious casualties. We simply don't know. Judge Ahmed goes on to explain the new law under the Domestic Abuse Act, which I will put up on the screen. Domestic abuse is defined by Section 1.1 of the Domestic Abuse Act of 2021 as being abusive behaviour between people personally connected to each other. Behaviour is abusive if it consists of any of the following: physical or sexual abuse, violent or threatening behaviour, controlling or coercive behaviour, economic abuse, psychological, emotional or other abuse. It does not matter whether the behaviour consists of a single incident or a course of conduct. Let me draw my breath a minute. So everything that may be deemed as inappropriate parenting, or even those horrible rows where sometimes unsavoury things are said between couples, is now domestic abuse. I'm not talking about the serious nature of domestic abuse here, where the police or other agencies could be involved, where a person reaches out for help and support, or can evidence a pattern of coercive control in its true context. The issue here is that this law references every unfortunate incident involving abusive behaviour, even a single incident, however trivial, as domestic abuse. This is what it goes on to say in relation to children. Under Section 3 of the Domestic Abuse Act, a child who sees or hears or experiences the effects of abuse between his or her parents is considered a victim of domestic abuse. So what Judge Ahmed did next was to apply these principles to the behaviour of the father, and this is what he concluded. The appeals judge stated the following, and I'm going to paraphrase for ease of reference. In this case, there was a constellation of failures in the judge's consideration of the domestic abuse issue, including whether certain conduct constituted abuse. In particular, Judge Watson failed to identify and apply the correct definition of domestic abuse. The description by Deputy Judge Watson of such abuse as being merely inappropriate parenting was inadequate, as it minimised the father's alleged conduct. Let me repeat that. Minimised the father's conduct. So applying common sense understanding and humanity to a child arrangements process, as Judge Watson clearly did in these two incidents, is according to the law minimising the father's alleged conduct. It gets worse. With respect to the incident where the son farts on the father and the father responds with understandable expletives, the appeal court states that excusing the father's expletives was wholly inappropriate and not what one may expect a judge of the family court to condone. Let me try and understand this. So, instead, the appeal court expected Judge Watson to throw common sense out of the window and now, in law, to formally label the father as a child abuser under the Domestic Abuse Act of 2021. I think I really am at the Mad Hatter's Tea Party. Let me put this into context. My teenage son farts at me and I respond instinctively as a parent and human being. And I call him a little shit. A few years later, I separate from my wife and I am forced to resolve child arrangements through the family court, where my ex seeks to demonise me, drag me through the mud and raise every historical issue in relation to inappropriate parenting. And through a fact-finding hearing, can now get a judge to legally label me forever as a child abuser. You might as well put a tattoo of child abuser on my forehead right now, because given this judgment and some of the challenging and difficult parenting situations that I faced as a parent and father in bringing up our beautiful and wonderful children into adulthood as kind, considerate, loving and well-adjusted human beings, that is what a court would do to me. Oh yes, it gets even more incomprehensible. His Honour Judge Ahmed states in relation to this case, any findings made or not made by the court were likely to be relevant to the nature of future contact between the father and the child. So what on earth is he suggesting? He is indeed suggesting that if your son farts on you and you respond with expletives, not only is that child abuse, but it actually has relevance to the nature of future contact between you and your child. Bloody hell. Let me play that scenario through. I say to my son, "You just farted on me, you little shit." And years later, the family court considers that to be relevant to seeing my child in the future. Am I going to have contact stopped or delayed? Am I going to be sent on a domestic abuse perpetrators course for child abuse? According to His Honour, Judge Ahmed, it appears that every single incident of inappropriate parenting has got to be labelled as abuse under this law, and as such must be relevant to future contact considerations. If calling your teenage son on one occasion a little shit justifies that incident to be heard as part of a fact-finding, then has the Court of Appeal just set that as the benchmark to be followed by all family courts? How many of those types of ridiculous incidents will the court consider when your ex drags them up? That appears to be the nightmare standard that the Court of Appeal has just set. Calling your 15-year-old son a shit once and using expletives when he farts on you has been determined by the Court of Appeal as issues of relevance for contact. You know, a judge in court sits under the royal coat of arms with the motto Dieu est mon droit, God is my right. I sincerely believe that now needs to be changed to say God help us, because as parents going through the family court, if there is a God, we're going to need that help, and we had better start praying for it right now. So it is now established in law that the family court under the Domestic Abuse Act is no longer allowed to apply common sense, humanity, sound reasoning or any level of human understanding. They have to apply the law. They have no choice. This has fundamentally changed the family court overnight, and it is as serious as it can get. On the other hand, we have the head of the family court division desperately calling for a new solutions-based approach to the family court, because the current adversarial system is totally broken. Well, in order to adopt a solutions-based approach, you can only do that if you can apply common sense. But common sense has just packed its bags and left every family court building. So what now happens to any idea of the court adopting a solutions-based approach? It's dead in the water. Indeed, it's going to go the other way. Whilst there is a critical need to drain the family court of the cesspit of human hate and acrimony, this law is going to fill it up quicker than it can be emptied. It's going to overflow. Every parent who wants to destroy the other with hate, acrimony and venom can now do so. It's an open season on hate. Any parent can now drag up every little incident in the past, and all you need is for some of it to stick. And there you have it, your victory. The court on your behalf will now legally label your ex as an abuser. The substance no longer matters. If the mission is to bring down the other parent with a label of abuser, then the family court will do it for you. It's now a rubber stamp. What if the parent at the receiving end of that hate, usually the non-resident parent, is a teacher, a doctor, a social worker, a scout leader, a police officer, a public figure in a position of trust or authority, and the family court now labels them in law as a domestic child abuser? Oh, what fun the other parent can have with that. So how does a person faced with this very real threat now respond to it? Do you just take it on the chin? Or is your only option now to fight back? If you're going to drag up my past, I'm going to drag up yours. Let's go to war. Mediation perhaps needs to change to be called a mudslinging and reconciliation meeting, where both parties get to place all their mudslinging on the table before any application is made to the court, in the hope that both parents apply their own common sense and decide that it's simply not worth it. If courts aren't going to apply common sense, that only leaves the parents to try and do it themselves. Unfortunately, where emotions are out of control, that's unlikely to work. I have previously described the family court as a boxing match which invites parents through its doors to fight it out. That has suddenly become an understatement. The family court is potentially about to turn into the Colosseum gladiatorial arena, where parents are literally going to try and slaughter each other. That is where we are heading. All the focus on the children is going to be entirely lost. There is one more thing that I think is going to be totally unforgivable and indeed sick. Once a parent gets labelled in law as a domestic abuser or child abuser as a result of nothing more than everyday understandable family incidents, will that then empower one parent to turn the children against the other? Your dad abused you. He is a child abuser. The court has said that your dad abused you as a child. This law is going to be used not to progress relationships and build loving bonds. It is going to be used to destroy relationships and in doing so destroy the lives of children. I also fear that for many parents, particularly fathers, that this could be the last straw in terms of mental health. Going through family court to seek access to your children can crush your mental health. And if through that process fathers are systematically going to be dragged through the mud and in the absence of all common sense labelled as domestic abusers under this law, then for some they may totally break. It would not surprise me if some may consider suicide or even commit suicide. We are now firmly in that territory, and as a former police officer I know what that looks like and the devastation when you have to tell their loved ones. The family court needs to be closed down. When you remove the ability of insightful, good and honest judges such as Deputy District Judge Watson to make appropriate, wise and sound decisions based on what is in front of them, and to apply human understanding and common sense, then no child issue should ever be allowed to enter through its doors again. The family court now represents a clear and significant danger and risk of harm to every child and every parent. If before it was only broken, it is now a totally dysfunctional, harmful and flawed institution that needs to be terminated. I don't think anyone really considered or thought through the impact that the Domestic Abuse Act would have on the family court, and with this first court of appeal judgment of its kind, we are now starting to find out what the reality looks like. I'm done, and I'm going to conclude with a visual representation of what I believe that the family court has now become. I also provide a web address if you would like to personally contact me. I'm looking forward to seeing you all again in my next blog.